All right. Trying to get this new studio just right. Let's see. Wish I could eliminate the glare from a ceiling fan light and still be bright enough to be seen. Let me cut that light and see what happens here. Let's try to get this switch over here. Okay. That may be better. Huh. Can't see my face as well, but who really wanted to see my face anyway, right? Okay. All right. Then I got the chair for those intimate close-ups, like when we're deep in thought, So there you go. Okay. Well, I said it would start at 5:51. It's 5:52 on my clock, so I better get this party started. Welcome back, everybody. Welcome back. Got my intimate chair over there. And I'm standing here. Welcome back to Florida Constitutional Law. Sorry to start a few minutes late, but I wanted to get us a big screen. Guess I managed to do that. Wanted to give us an impression of what we'd be covering today. So got that here. Got an email from at least one of you to ask, where are we on this crazy syllabus of ours? You may recall that I mentioned in a live lecture, or perhaps even two, that my goal was to get ahead of the syllabus, and that's not a selfish goal. To the contrary, I wanted to get ahead of the syllabus so that we could carve out time that I could spend on a review of the entire semester and to do that before the final exam. So far, mission accomplished. We are at least one full class ahead of the syllabus. This is class number 8. It's the 8th time we've met together. And the topics that we'll be covering today are listed or scheduled on the syllabus to be covered in class 9. So we're an entire class ahead from that perspective, but we're actually a little bit more than an entire class ahead because our first topic, separation of powers, as you recall, we already discussed that topic. We already started that chapter. We spent 28 minutes of coverage on what is a rather short chapter. So that's going to turn out pretty well. So we're a little bit ahead. And since we're a little bit ahead, that gives me one moment to grab the book. Be right back. Got to step over the wire. Be right back. I can enter this way too. Hey, I don't have special effects for the video, so that's the best I can do. But let me start this class the way I've started every class this semester, and that's to start with a prayer. As always, I'm praying for you. I'm praying for your intentions. Obviously, there's much to pray about in our current condition that the world finds itself in. So this prayer goes out to you for your health, your well-being, and the health and well-being of your friends and your loved ones. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, we fly unto thee, O Virgin of Virgins, our Mother. To thee do we come, before thee we stand, sinful and sorrowful. O Mother of the Word incarnate, despise not our petitions, but in your mercy hear and answer us. Jesus, I trust in you. Jesus, I trust in you. Jesus, I trust in you. Amen. In the name of the Father, Son, Holy Spirit. Amen. Thanks for letting me pray with you. Pray for you. The only thing better than that is when we've got someone to join us. You remember, if you were at class 1, lecture 1, first few minutes, we had Deacon Tommy Cuff from the Archdiocese of Orlando join us. And with current conditions the way they are, with so many of us concerned about the world, I thought it'd be comforting if Deacon Tommy Cuff came back to join us again. And he didn't hesitate to answer that invitation with a yes. So we've got Deacon Tommy Cuff with us. Of course, with social distancing, with the coronavirus, with the quarantine, he'll have to be at a distance. I'm going to put him here on the big screen if I get the tech right. Of course, technology is always a challenge, is it not? Let's see what we can do here. Is this it? This is it. I asked him to join us at 6 p.m. On my clock, it's 5:58, so it may be a little early, but forgive me while I reach around and press a few buttons here and hopefully get this party started. Oh, we got a camera of me. What I want is Deacon Tommy. Oh, now I have a picture of me. Hey, not bad. Patrick's over there. Hey, Patrick, what looks better, the photo or the real thing?
You.
Excellent answer, Patrick. Patrick, did you want to say hello to the class? They loved seeing you last week. No? Okay. So I presume this becomes Tommy once Deacon Tommy joins us. Is that how it goes? No? Of course, if that technology doesn't work, I've got the old-fashioned cell phone. I can give him a call. Oh, somebody just said hi, Patrick. Laugh out loud. They said hello. Patrick says hi. All right. So Tommy will join us. Let's see. Oh, he wants to be admitted. I have to hit the admit button. I think we'll admit him. What do you say? All right, here we go. Hey, Deacon Tommy, you are live.
Hello.
Hello, how are you?
Good, how's it going?
Oh, well, it's going great. I've got the class with us. I presume you see me straight on.
I actually see like a picture of you.
Oh, sorry about that. I think I have to hit a button so that you can see all of me. All of me. Why not take all? Okay. Hey, do you see me there? I've got this pointed in a bizarre way from your perspective. But let me point your camera a little bit so you can see that I've got you on the big screen. See?
All right.
Yes. Deacon Tommy, this is Deacon Tommy. Deacon Tommy, this is Deacon Tommy. There you go. Want to do an introduction. And, of course, I've got the entire class over this way. So, and they're happy to see you again. Sorry that it's not two-way communication. You won't hear them, but they'll hear you, and that's the most important part.
That's great. Well, I'm just happy to have the opportunity to say a few words to everybody again.
Well, thanks, man. And I told them when I invited you, you did not hesitate to come on back, and I really appreciate that. You know, you give a guy an inch and he asks for a yard. I asked for a little bit, but then I want more. So sorry about that. But, you know, 6 months ago, even 6 weeks ago, who would have predicted this? And by this, of course, I mean that Tom Brady would be the quarterback of the Tampa Bay Buccaneers. That joke never gets old.
That's what I knew the apocalypse was coming.
Oh, there you go. But will your Buccaneers do better next season?
Oh, yeah. I mean, God willing, there's a season. I see no reason why we shouldn't be deep in the playoffs.
Yeah. Gosh, I hope you're right about that. So.
I think we were on the verge anyway. Brady's going to help us out. There's no doubt about that.
Well, as an FSU alum, I thought my fellow Seminole, Jameis Winston, was a great quarterback, and I wish him well. But I'm excited to see what Tom Brady can do.
Me too. I think Jameis has some potential, but you know, it's hard not to take a shot at Tom Brady if he gets a shot. So.
Right? Who turns down the opportunity to have Tom Brady start for him? But of course, it wasn't sports that I brought you here to discuss today.
Right.
Sorry about that, y'all.
Whenever you're ready, shall I?
Oh, I'm ready. We're live. We're in person. Everybody's watching us and thinking we're either nuts or good friends.
Okay. Well, yes, we begin all things in the name of the Father, the Son, and the Holy Spirit. Amen. And I would just ask, dear God, please bless our thoughts and our words. Please bless our ears and our minds and our hearts. And please watch over us as we all live in a particularly troubling time right now. And we pray that you give us the grace to go on faith and to allow your comfort into our life. So please watch over us as we meet together here remotely, but together briefly. And we pray your blessing on Professor McGinley and his wonderful class of law students. And we know that they are here with the greatest intentions of making a mark on the world and making a mark for their families and themselves in an honorable way. We pray that you just bless them and hold them in the palm of your hand. Pray this all through your Son's name, Jesus Christ. Amen. Father, Son, Holy Spirit. So good evening, and thank you for allowing me to chat with you for a minute. Professor McGinley asked if I would mind doing a blessing, and then we talked a little bit about it. And we thought we'd just say a few words about what's going on. And I basically just wanted to reflect a little bit on the scriptures that the church has put forth for us today, that the Catholic Church around the world is observing and meditating on. And you know, the first scripture, I'm not gonna spend 6 or 7 minutes reading scripture, but I'll just sort of like tell you about a couple of spots that jumped out at me as it correlates with what we've got going on in the world right now. In the book of Numbers, it talks about the Israelites. You know, the Israelites had many issues after they were released from Egypt. You know, God delivered them from the land of Egypt, and they set about crossing the wilderness and trying to get to the promised land, where they could settle and live their lives the way they wanted to. But they kept getting off course, and lots of times it had to do simply with a lack of faith. Here, God had delivered them from the Egyptians, and the Egyptians, as we all know, at that point in history, they were the United States, you know, or Russia or something like that. They were a strong world power, and they were brought to their knees and to the point that they had to let their slaves leave. So a very powerful statement, something the Israelites should have been able to derive great faith from. But you know, every time something went south, so to speak, in the wilderness, their faith was shaken to the point that they would turn on God. God, why are you letting this happen? God, you let us out here so that we could die. We'd be better off back in Egypt as slaves. At least we had food to eat. These were the things that they would say over and over again. Well, the way Numbers lays it out for us, God at one point had enough of that type of murmuring and a lack of faith. He allowed poisonous snakes to enter amongst the community. And they began to bite people, and people began to die. And Moses, the leader of the Israelites, went and pleaded on behalf of the people to God and said, God, please, please save these people. Give them an opportunity to be delivered through this plague. And so God said, okay, make a bronze serpent and lift it up high on a stake. And whoever looks at that serpent, if they've been bitten, they will live. So this was a call to faith. And Moses did just that. He hammered out had a bronze serpent made, wrapped around a big stake, and set it up so that all the people could see it in a prominent place. Your people that were dying of snake bites were able to look upon that serpent and live. And certainly what they were doing was they were demonstrating their faith. And they had and honestly, it was kind of interesting because their faith, it seems to me when I read that, came from a place of desperation. They had nothing else to have faith in at that point. I'm gonna die, I might as well try and look at the serpent, and it worked. They lived. So they got back on track, and as we know, they eventually did make it to the promised land. But what an interesting account. And many times, and Jesus sort of got into that today a little bit. He said that for those that would lift him up and understand that he was correlated with God the Father, and that basically he was God amongst them. For those that would have faith, they would live and they would survive. He was talking to Israelites there that were also dealing with their own problems. They were occupied by the Romans, and they were persecuted and held down. And that they certainly were looking for deliverance too. And here Jesus was asking them, once again, all these years later, look upon me as your Savior. Have faith. So I'm not suggesting that we, erect a copper serpent or a bronze serpent to look at this time. But one thing that works for me, and I know it does for Professor McGinley and his family, and I pray it does for you all too. Look upon the crucifix. Lots of times in Catholic teaching, there has been a parallel drawn between that bronze serpent in the desert and the crucifix that we look upon in faith today, because that's our way of lifting Jesus up. Take a moment. Men and women, brothers and sisters, there's no question. You all have your own set of pressures and anxieties surrounding what's going on. So do I and my family. So does Professor McGinley and his family. The whole world is in uncharted territories right now, but we will get through it. And there is a peace that can come to us right now if we're willing to look upon the crucified Christ. Look up and adore that crucifix. Take a little quiet time to just clear your mind and be in silence for a few minutes a day, if possible, and gaze on that crucifix. Just like those Israelites did in the desert when they had nowhere else to turn and it seemed like the death was imminent. They were able to look upon that serpent and do so out of faith in God's ability to deliver them. And indeed it did. Well, Christ on the crucifix, Christ on the cross offers a lot more hope than a bronze serpent, does it not? It's a reminder of the fact that God came down and gave us a way out, and he will give us a way out of this. And in the meantime, I think the thing that's going to wind up affecting all of us more than anything, for the most part, is anxiety and the way we deal with it. So we need to have something, we need a rock to hold on to in the storm, and we've been given that. So look upon Christ crucified, look upon the cross, give it an opportunity for, if you can do it for 2 minutes a day, I would say that if you do it for 2 minutes a day, and give yourself that quiet time and offer up your anxieties and your struggles and your pain and your fear to him, that 2 minutes will probably turn into 5 minutes and then 10 minutes. And who knows, you might have a really nice prayer system going, gazing upon that crucifix, which is certainly our hope in this troubled world. So I thank you for your time, and if anybody would like to talk about anything, or just if anybody has any questions, or if anybody wants to be prayed with, or whatever the case might be, please reach out to Professor McGinley, and I would be more than happy to do that with you if anybody feels the need or their families feel a need. So just make myself readily available for that, and I will be praying for you all in a special way. It was so nice being with you at the beginning of your journey this year, and as Professor McGinley pointed out, it's amazing how quickly things change. And here we find ourselves in these very odd circumstances, but here we are. We can get through it together as God's people and as a family, following the cross and gazing upon Christ crucified. And I and my family will be praying for you, and I would just like to close out with offering a special blessing to you tonight. So we'll close by saying, dear Father in heaven, once again, we ask you please watch over these young people and our families and your church and our country and all the people in the world. We pray that your will be done. We pray that you help us to weather this storm by putting our faith in you and laying our burdens upon you and knowing that you always have a plan for us, a great master plan. So please watch over us. Please give us that peace that we're all all looking for and that everybody in the world needs a little bit of. And we pray that here in this Lenten season, as we approach Holy Week next week, this is what a special time to think about your son and the suffering that he did on our behalf and the things that he endured and the beautiful and miraculous deliverance that he had on Easter Sunday. This is what we all have to look forward to. So please bless this class of future attorneys. Please bless Professor McGinley. And once again, we know that they're going to do great things in the world and they have the best of intentions. So please hold them in the palm of your hand. Please deliver them through these odd times and help them to look with hope on the goals that they have set earlier. And we will all certainly be there together and be there for them. And we close tonight in the name of your Son, Jesus Christ. Amen. And I bless you all in the name of the Father, the Son, and the Holy Spirit. Amen.
Amen. Deacon Tommy, thank you. Thank you so much. That was powerful and that was beautiful. And now I got to follow that somehow.
I've seen you. I think you'll be fine.
Well, thank you. But I really appreciate you taking the time. And I speak for everyone when I say thank you. Thank you so much.
Please give them my love.
Yep, they hear you and they feel it.
If you talk or anything like that, just send them my way.
I'll do that. Everyone's got my email, patrick@mcginleylaw.com. If you don't have my cell phone, email me. I'll send you that. I'll get you in touch with Deacon Tommy. Tommy, thank you so much, man. I really
Thanks a lot,
appreciate it.
God bless. You guys have a great class.
God bless you too.
We'll
All
see you
right.
soon. I'll talk to you soon.
All right. I'll let you go. I'll slap down this intercom. Thank you. Thank you so much. Well, I really appreciate that. I hope that worked well for you too. Let me switch over the inputs here on the television. Get us back to our slideshow. So I think that was HDMI 3. Nope. That was the TiVo. Okay, here we go. All right. And we are back. So we're a little bit ahead of the syllabus, so we've got time for a powerful prayer like that. And I hope it meant something to you. It sure meant a lot to me. But with that said, time to get to work. Let's take a look at separation of powers. Or I should say, separation of powers redux. Redux means return, right? I try to use big words sometimes. I don't even know what they mean. Separation of powers, part 2. How's that sound? All right. So let's take a look now. We covered more than just the introduction part, and now we're up to dissension among the branches. And it's laid the groundwork for this particular case that we're going to talk about here. Because when it comes to dissension among the branches, you can't get much more dissension than this. This is Florida House of Representatives versus Chris. This is written by Raul Cantero. I told you, when he writes an opinion, that opinion's worth reading. Great writer. So I hope you took my advice. I didn't edit this opinion as heavily in text as I've edited so many, because with such powerful words and such great words, which ones do you delete? Hey, wait a minute. Check out my head and the lamp. Looks like I'm wearing like a crown, right? Let me see if I can get that out of it. Bad enough I got people calling me professor today. I don't want people calling me king. I'm neither a professor nor a king. Okay, well, there we go. All right, how's that? Better? Okay, so there you go. So we return then to Florida House of Representatives versus Chris. And this case involved a dissension among the branches. Certainly, there was a fight on their hands. And the opinion opens by noting that after almost 16 years of sporadic negotiations with 4 governors, in November 2007, the Seminole Indian Tribe of Florida signed a gambling compact. And right there, you got a definition of compact. And that's an important thing to know. What is a compact? Is a compact a contract? Well, it is if both parties to that contract are themselves sovereign, or a sovereignty. For example, a nation, such as the Seminole Indian Tribe of Florida, such as a state, such as the state of Florida. So you have the state of Florida, it's a sovereign. You have the Seminole Indian Tribe of Florida, it's a sovereign. And when the two make a contract, we have a special name for that type of contract. We call it a compact. So we've got a compact now. And what was the point of this compact? Where did it come from? Well, there's a reference here to a federal law, and that's the IGRA, Indian Gaming Regulatory Act. That was at the time at 25 U.S.C. Section 2701 et sequitur. We'll talk about the 2000 version when it comes to this particular 2008 case. And under that federal law, the sovereigns who were, such as the Seminole Indian Tribe of Florida, who were Native Americans, had the right to enter into compacts with the states that happen to have overlapping jurisdiction over their territory, so that there could be gaming within the sovereign Indian nation's territory. So in order to do that, however, there had to be an agreement in advance. And as the opinion laments, there have been 16 years of on again, off again, on again, off again negotiations, but the Florida legislature never quite sealed the deal. So then Governor Charlie Crist took the initiative, and he decided to enter into such a compact. And that's exactly what he did. Now, how did the compact differ from what kind of gaming could be happening in Florida to begin with? So, for example, bingo, in certain circumstances, is allowed within the state of Florida at this particular time period in this case. And there were not quite slot machines, but gaming devices which added a skin or a screen or a graphic display to the bingo that made the bingo look a lot like a slot machine. But ultimately, underneath it all, behind the skin, behind the graphic interface, you were still playing a bingo game. It just looked a lot and it felt a lot more like a slot machine. Those were allowed at the time. What was different about the bingo versus other types of gambling is that it was parimutuel. That is, it wasn't a banked game. Parimutuel versus banked. Parimutuel means we take all the bets, we put them together, the house gets to keep its rake or its take or its cut, and the rest is divided among the players, with obviously winning players getting a lot more and losing players getting either a lot less or none. So this is a parimutuel game. Compare that to a banked game. A banked game, the house stands to gain or to lose, at least in theory, based on the outcome of each game. The players as a whole stand to either recover more or less than the sum total of all the players' individual bets in a banked game. So when you look at the parimutuel game, ultimately, the only money that's changing hands is the money that the players put in. The rake, the take, the cut goes to the house. The rest all goes back to the players. Not so in a banked game. In a banked game, just hypothetically picking numbers, all the players might bet some total of 1,000, but the total winnings might be 2,000, 8,000, 10,000, 12,000. So that's the difference. Now, what the IGRA allowed was that there could be a compact allowing the sovereign Indian nations to have banked games, such as blackjack, such as one of my favorites, if you like to roll the dice, craps, such as games that allow for banked. That's what was going on here. Now, if negotiations fail under the IGRA, that allows the tribe to sue the state in federal court. If the state continues to refuse consent, then the secretary, we're talking about a federal government official here, the secretary may prescribe procedures permitting this type of banked gaming. The United States Supreme Court has held, however, in a case involving the Seminole tribe's attempt to offer Class III gaming in Florida prior to this one, that the IGRA did not abrogate the state's 11th Amendment immunity, and that alludes to sovereign immunity. That alludes to the second half of our lecture today. So we'll return to the sovereign immunity issues here. But returning now to the issues that this case of Florida House of Representatives versus Crist raises when it comes to separation of powers. What you had here was the governor cut a deal, a compact, that allowed for banked gaming, not throughout the state of Florida, but throughout that part of the state of Florida that was within the territory of that sovereign nation called the Seminole Indian Tribe of Florida. So you could do something in part of Florida that you couldn't do in the rest of Florida. Also important to note, the Florida statutes made it illegal indeed a crime, for this type of banked gaming to take place. Yet the compact between sovereigns allowed it to a limited extent within the Seminole Indian tribe of Florida land. So what happened was a particular extraordinary writ was filed. In our last lecture, we talked about various extraordinary writs. Did you know which one was used here? It was a writ of quo warranto. A writ of quo warranto was filed by Marco Rubio, who at the time was not a U.S. Senator. He was part of the Florida legislature. Indeed, he was the Speaker of the House at the time. He filed a quo warranto on behalf of himself as an individual and on behalf of the Florida legislature. Who was the writ directed against? It was directed against a statewide officer, specifically Charlie Crist, governor of the state of Florida. So who has jurisdiction then over a writ of quo warranto filed against a statewide officer? Supreme Court of the state of Florida. So here we have the ultimate showdown, if you will, in a separation of powers battle. We've got the highest court of the state court system, the Supreme Court of Florida, hearing a dispute between the Florida House of Representatives, part of the legislative branch, versus our chief executive, our governor of the executive branch. So we certainly have here the ultimate separation of powers showdown, don't we? Now, what do we learn from this case? What's the lesson? What is the takeaway? I propose to you that there are at least 6 things that you should take into mind from the outcome of this case. Let's look at them one at a time here on the big screen. First, the Florida Supreme Court has quo warranto jurisdiction alleging a violation of separation of powers and has that jurisdiction even after the act has occurred. Whoa, I know what you're saying. McGinley, I don't like part 2 of your 2-part sentence there, but remember we addressed that in greater detail in the notes and questions to consider at the end of this very case. So can you do this before it occurs? Can you do it after it occurs? We'll talk about that in some more detail. But for now, one of the 6 takeaways from House of Representatives Chris is this, that the Florida Supreme Court does indeed have quo warranto jurisdiction, alleging a violation of separation of powers, and certainly has that jurisdiction after the act has occurred. Does it have it before the act has occurred? We'll explore that in greater detail in our notes and questions to consider in just a moment. That's takeaway number 1 of 6. Takeaway number 2, the necessary business clause of Florida's Constitution does not authorize Florida's governor to execute compacts that are contrary to the express public policy of the state or to create exceptions to state law. So what is point 2 saying? Point 2 is saying that we have an executive branch under Florida's Constitution. It is led by a chief executive who we call the governor. And there is a clause called the necessary business clause. You read it in the opinion. The governor has the power to conduct all the necessary business of the state of Florida. But does that give him the power to execute compacts that are contrary to the expressed public policy of the state? And the answer is no. So we have a limitation upon the necessary business clause. That's takeaway 2 of 6. Takeaway number 3, unless there is a tribal state compact allowing gambling, any gambling prohibited in Florida is prohibited on tribal land. Why is that? Remember class number 1, don't forget lecture number 1. When it's a battle, generally speaking, between a federal law and a state law, the source of the federal law might get lower and lower and lower, as you remember from lecture 1. The summit of state law is our state constitution, but even those lowest level federal laws preempt or trump or take precedence over even the highest expression of state law, generally speaking. And here's yet another example of that happening. That's takeaway number 3. Takeaway number 4 of 6. By authorizing the tribe to conduct banked card games that were illegal throughout Florida and therefore illegal For the tribe, this tribal state gaming compact violated state law. So, despite this being a contract between sovereigns, it was an illegal contract. Takeaway number 5 of 6, the governor's execution of a compact authorizing types of gaming that were prohibited under state law, that was a violation of the separation of powers. So we know that there is a limitation upon the necessary business clause. We know that it was illegal to do throughout the state. So despite the IGRA and the federal law allowing for a compact, this was not legal because it was a violation of separation of powers. And takeaway number 6, Florida's governor lacked authority to bind Florida to a compact that departed from our state's public policy by legalizing types of gaming that were illegal everywhere else in the state. Oh, some terrible glare like at the bottom here. Let me see if I can move that lamp. I'm going to get these studio problems all worked out in the end. Bear with me while I move the lamp. If I can, which I think I could. Put it down here, maybe. That helps. Maybe you'll be able to see the slide a bit better. Oh, and it still shines on me without giving us as much glare. I still got my crown on my head, though, don't I? I'm having fun with this. Hope you all are, too. So those are 6 takeaways that I think are important to take from Florida House of Representatives versus Crist. Let's take a look at our notes and questions to consider, shall we? First, let's take a look at Note 1. Note 1 says a question. Which branch of Florida's government does Florida House of Representatives versus Crist hold to be the branch that determines the public policy of the state of Florida? I think the answer is clear. It's not the executive branch. And since we didn't see an act of judicial activism, I think it's equally clear that it's not the judicial branch. The outcome of this case, I think, leads to only one answer to this question being which branch is the branch that determines the public policy of the state of Florida. That branch is the legislative branch. It is the Florida legislature that determines Florida's public policy. I don't see a way to read Florida House of Representatives versus Crist in any other way. Did you notice what the court did with the writ of quo warranto? They said that Florida House of Representatives, that Marco Rubio, that the petitioners were correct. Did they issue the writ? No. All the elements of a petition for writ of quo warranto were pled, were proven, were satisfied. All the elements of the action were there. But yet, ultimately, in the very last page, they didn't issue the writ. Check it out. Conclusion. I'm reading from the opinion now. We conclude that the governor's execution of a compact authorizing types of gaming that are prohibited under Florida law violates the separation of powers. The governor had no authority. Therefore, we hold that the governor lacked authority. We need not reach the broader issue of whether the governor ever had the authority, because we believe the parties will fully comply with the dictates of this opinion. We grant the petition, but withhold issuance of the writ. Remember when we studied extraordinary writs? What made them extraordinary? What made them extraordinary is that the relief, the remedy, is always discretionary, even if the party who's seeking the writ pleads and proves all the elements of the action. The court still has the discretion to deny the remedy. That's exactly what happened here. And in so doing, Supreme Court of Florida showed great deference to the separation of powers, did it not? So the governor would read the opinion and would obey it. The Florida Supreme Court was so confident of that, they didn't enter the writ. And in order to have the judicial branch step on the toes of the executive branch, the writ wasn't issued. So who is it then that's setting public policy? Was it the judicial branch? No, they didn't even issue the writ. Was it the executive branch? No, they lost the case. Clearly, the answer to Note 1 is the legislative branch. I don't see how you can read the case any other way. Let's take a look at Note 2. It reads, An extraordinary writ like a writ of quo warranto is a discretionary remedy. And so a party that proves its entitlement to such a writ may still be denied issuance of that writ by the court. Indeed, here in Florida House of Representatives versus Christ, Florida's Supreme Court found that the House of Representatives was entitled to such a writ, yet the court withheld its issuance. In what way was this in deference to the separation of powers? I think it was in great deference to separation of powers and was an acknowledgement that the legislature was the policy-making branch for the state of Florida, not the judiciary, not the executive. Let's take a look at note 7. It reads, Florida House of Representatives versus Christ holds that Florida's Supreme Court has quo warranto jurisdiction alleging a violation of the separation of powers, and has that jurisdiction even after the act has occurred. This holding defeated the governor's defense that the House could have acted sooner and failed to act in time. Is it for one to wait and suffer the harm inflicted by a violation of the separation of powers before one may seek quo warranto relief? Consider this holding from footnote 1 of League of Women Voters of Florida versus Scott, case we studied earlier. We recognize that Florida House of Representatives versus Christ contains language suggesting the writ could be used to prevent future conduct. However, the history of quo warranto as well as our precedent belie any suggestion to this effect. In Christ, we explain that petitions for the writ historically have been filed after the public official is acted, and the disputed act has already occurred. In that case, the Florida House of Representatives challenged the execution by Governor Christ, of a compact with the Seminole Indian Tribe of Florida. So what we see in this later case, 2017, is a suggestion that, yes, we do have to wait until after a violation of separation of powers has occurred. We do have to wait until after suffering the harm before we can seek an extraordinary writ of quo warranto based on a violation of separation of powers. Is that good? Is that bad? Well, it's a policy decision. And I guess if you're in a court of law, you might argue policy. But of course, policy should be the domain of the legislature, not the court. That brings us to note 8. Note 8 reads, Article 4, Section 1 of Florida's Constitution states that the supreme executive power shall be vested in a governor who shall transact all necessary business with the officers of government. That is what we referred to earlier when we talked about the necessary business clause that appears in Florida's Constitution. This case, Florida House of Representatives versus Christ, holds that the necessary business clause does not authorize Florida's governor to execute compacts contrary to the express public policy of the state. Does this make the authority of Florida's governor different than the authority of a U.S. president? And you know, because you took federal constitutional law before taking this class, that I like to draw upon your existing knowledge and expertise in comparing and contrasting federal law, federal constitutional law, with state constitutional law. In order to do that, I have to, unfortunately, run roughshod over politics. If by doing so I'm offending anyone's politics, I apologize. But I want to compare and contrast. So let's do that. Does this make the authority of Florida's governor different than the authority of a U.S. president? Consider, for example, the proposed, quote, Development, Relief, and Education for Alien Minors Act. That's D, Development, R, Relief, E, Education, A, Alien, M, Minors, sometimes called the DREAM Act. Was the DREAM Act before the U.S. Congress? Yes. Did they vote on it? Yes. Did they vote to approve it? No. Did it pass into law? No. The DREAM Act failed. It was not passed into law. It is not part of the United States Code. It is not a federal statute. What happened after the DREAM Act failed to be passed into law? Well, then the U.S. president created DACA, Deferred Action for Childhood Arrivals. And in no small way, the effect of DACA is the effect that would have happened had the DREAM Act been enacted into law. Many of the provisions of DACA and the DREAM Act operate quite similarly. In other words, the legislature of the United States decided not to do this, but the executive branch of the United States, through DACA, through the president, went ahead and did it anyway. So the question I ask here is, does Florida's governor have a similar power to implement a public policy that Florida's legislature decides not to implement? And I would suggest that Florida House of Representatives versus Christ says the answer is no. Florida's governor cannot do with the DACA what happened with the failed DREAM Act. As we compare and contrast the alleged power of the U.S. presidency, and it's still working its way through the courts as we record this lecture on March 31st, 2020, the alleged power of the U.S. presidency to essentially create the DREAM Act by executive order called DACA. Certainly that is not a power that the Florida governor has under Florida's Constitution. As DACA makes its way through the federal courts, we'll find out ultimately whether that's a power that the U.S. president has under the U.S. Constitution. So perhaps as of today, that's an unanswered question. But it's certainly an answered question under Florida House of Representatives versus Christ, whether Florida's governor has that power. And the answer is no, Florida's governor does not have that power. So that brings us to our next section, which is cooperation among the branches. And in this section, we examine two cases kind of at once. They're just a few months apart. They both happened just a year and a half ago or so. Delizzle. I really would like to meet this individual, so I know how this individual chooses to pronounce this individual's name. I'm going to go with Delizzle versus Crane Company. We're going to compare and contrast that to in re amendments to Florida's evidence code. And we're going to do that after we take a 7-minute break. Enjoy your break. Get something to drink. Make sure it's not intoxicating. And I'll see you back here in 7 minutes. Until then, it's quite a beautiful slide, so I guess I'll just zoom in on it for you. Do you like my color choices? Usually I just go with the black and white, occasionally yellow. I thought you might like some green. Enjoy. See you in 7. Shore Park Avenue pizza?
Yeah.
How was it? Ooh, those are pretty nice. You can put that on your nails? That'd be nice. I'm sorry about that. Like this.
Okay. So mommy, I tested it out, and then I wiped it off. Oh, okay, good. Because I want to know if it's actually like color or it's like clear. So we should. So could you like the head of you want?
So cool.
Mommy. Set a timer for 1 hour. 1 hour. Time now.
Coming back soon.
Where are you?
Still looks like I got a crown on my head. Hey, Bernsey, I got that angle of the camera set up. It looks like this thing is like a crown I'm wearing on my head. See?
Not really.
I'm like King Patrick. Cool, right? All right. Is it 7 minutes yet? Let's get that screen back in there. Let's see. Hey, not bad. All right. Okay, welcome back, everybody. Welcome back. I guess the nice part is if your particular break goes too long, isn't there like a rewind? I know you can always play this 24 hours a day, 7 days a week. So it's like 2 a.m. and you can't sleep. Just hit play on a McGinley video and bam, you'll be asleep in no time, right? So there you go. All right. Yes. All right. So we are now returning for the third time to separation of powers. We are at this part. We're talking about cooperation between the branches. In order to do that, we're going to compare two different cases just a few months apart. A little bit of background. Fry and Daubert. F-R-Y-E, Fry, and Daubert, D-A-U-B-E-R-T. What are we talking about there? Well, when it comes to litigation, one of the important tools that we lawyers have is the tool of an expert witness. What's an expert witness do for us? Well, an expert witness helps to explain technical data, helps to put a human face on that technical data, helps to interpret the data in such a way that non-lawyers might understand. This is particularly important in a jury trial. In a way, not in a direct way, but an indirect way, an expert witness is a conduit or a path through which seemingly inadmissible things become admissible, such as ultimate opinions. From a purely technical standpoint, the ultimate opinion is the province of the fact finder. But with that said, rather than just taking a stack of data and throwing it on the desk and telling the fact finder to go read it, when an expert witness helps to clarify, classify, explain, and put a face on that data, ultimately the expert witness is presenting a suggested conclusion. So getting the expert's testimony into evidence is sometimes a fight in and of itself. When is the expert's opinion admissible? When is it not? Well, it has to meet the appropriate test. The appropriate test might be Fry, or it might be Daubert. Different states choose differently. What's the difference between Fry and Daubert? Fry focuses solely on one question, and that is the method generally accepted in the relevant scientific community? So different experts might be within the realm of different scientific communities, but that particular community the expert is in, is the method used by this expert a generally accepted method within that particular scientific community? That's the beginning and the end of a Fry analysis. Daubert, on the other hand, is a list of criteria which tell us whether or not the particular expert testimony is admitted. In very many instances, it would be harder to meet a Daubert standard than it would under Fry, or at least some argue that that's the case. As you can see from some of the dissents and the opinions here, there's even a difference of opinion on that as to whether Fry does a better job of keeping out junk science or whether Daubert does a better job of keeping out junk science. We're not here to answer that question today. The question we're here to answer today is, who gets to make the call? Who decides whether it's Fry or Daubert? Who makes that policy decision? Where in our separation of powers between the executive, the legislative, and the judicial branches of Florida's government under Florida's Constitution is that decision to be made? And by comparing and contrasting these two cases, we're about to find out. Let's look first at DeLees. Going with the pronunciation DeLees this time. DeLees versus Crane Company. What happened there? What happened there is that the Supreme Court of the state of Florida decided that it was the Supreme Court of the state of Florida that would decide which standard was the public policy of the state of Florida. So this Deleuze was an example of the judiciary saying that the judiciary would set the public policy for the state of Florida. How could that be? We just studied Florida House of Representatives versus Crist. The only reasonable interpretation of Florida House of Representatives versus Crist was that it was the legislature that set the public policy of Florida. Well, here in Deleuze, the Supreme Court of the state of Florida attempted to carve out an exception. See, what had been going on here for very many years is that there was a cooperation of sorts. You see, what was explained was that when it comes to evidence and the rules of evidence, there was a union, there was a combination, there was both substantive law and procedural law contained within the rules of evidence, says the opinion of Deleuze. Since a rule of evidence is both procedural in a way and substantive in a way, the way the branches had worked that out was this. The Constitution of the state of Florida says that procedure is the sole part, solely to be decided by the judiciary. The judiciary decides procedure. Substance, however, is to be decided by the legislature. Since the evidence code was both procedure and substance, the cooperative way that this had been going on for very many years was that the legislature would pass an evidence code, and then the judiciary would rule whether or not that the evidence code goes into place. And almost invariably, for decades, the judiciary was deferring and approving and going along with what the Florida legislature had done. But there was an exception, as you saw pointed out in Deleuze. So pointing to that exception and reminding the legislature that procedure was the sole province of the judiciary, in Deleuze, they rejected the judiciary's choice of standard for admissibility of expert witnesses. So the people of the state of Florida, speaking through their elected representatives, had told the courts what was admissible, what was not, and the courts said, nah, and instead replaced the will of the people with the will of the particular judges. Now, that opinion was issued just a few months before the opinion in re Amendments to Florida Evidence Code. Again, both cases, as you see, Supreme Court of Florida, Supreme Court of Florida, same court. But there was a difference in personnel on the court. You remember from our last lecture, when Mikey Starks was our guest lecturer, he explained to us how there were 3 judges retiring at the exact same time. You remember that story? Well, those 3 judges hadn't retired as of this opinion and had retired as of this opinion. So comparing and contrasting the 2 opinions, although it's the same court, it's not the same personnel. And the personnel in the latter opinion decided that it was the will of the people of the state of Florida, speaking through their elected representatives as the Florida legislature, that should decide this issue. And indeed, this opinion overrules that opinion. So, cooperation among the branches, that's the example I give. And that brings us to our notes and questions to consider. Specifically, I'd like you to consider note 1. In Deleuze, Florida Supreme Court declines to replace the Frye rule with Daubert. A few months later, and with 3 retiring Supreme Court justices having been replaced with new justices, Florida Supreme Court replaces Frye with Daubert, just as the legislature had said to do, in its in re amendments decision. To what extent was the different outcome attributable to changed circumstances? Remember, these opinions are 4 months apart. To what extent was the different outcome attributable to changed circumstances? And therefore, we've got a different outcome. And that's not only a shallow analysis, but it is also a mimicry of what we hear of an analysis of the United States Supreme Court. We often hear it lamented that on the federal level, the federal Constitution in certain areas seems to just mean whatever the personnel of the United States Supreme Court happen to feel like it should mean at that time. And again, that's yet again a shallow analysis, but it's an analysis and a lament that we hear quite regularly in the popular news and in non-lawyer sources. It doesn't mean it's necessarily wrong, but it is a shallow analysis. The deeper analysis here is that the court returned to the question originally answered in Florida House of Representatives versus Crest, but it returned to that question under the more difficult circumstances of not a conflict, but a cooperation. Remember, the premise of both opinions agreed with this premise, is that the evidence code is part substantive, part procedural. Both opinions agreed that when it comes to substance, that's the province of the legislature. When it comes to procedure, that's the province of the judiciary. So the deeper analysis might be that what we had here was a more complex situation of not a conflict in the separation of powers, but a cooperation in the separation of powers. And to what extent must the judiciary continue to defer to the legislature in that spirit of cooperation when both are separate and both have their own individual areas of expertise and of power? In a way, it's a return to that question of subsidiarity. And it poses this particular solution that you see in there. So that brings us finally, after two different classes, finally to end. I'm holding up the lamp. I'm going to find the right place for this lamp. Yeah, we'll run with it. What brings us to a new chapter? A new chapter we'd like to take a look at is the chapter of sovereign immunity. So join me now on a sovereign immunity chapter. First question we should answer, of course, is what is sovereign immunity? How would you define sovereign immunity? And in my text, I gave you this definition. Sovereign immunity or crown immunity is a legal doctrine by which the sovereign or state cannot commit a legal wrong and is immune from civil suit or criminal prosecution. Am I saying that the government is above the law? Well, it does sound a little bit like what we're talking about here, isn't it? Sovereign immunity is a situation where you can't take the government to court. Sovereign immunity is a situation where the judicial branch does not offer a remedy against an action of government. So with that said, got to ask in this day and age, why do we hold on to? Why do we still recognize? Why is there still a sovereign immunity? Part of that question is answered by the fact that it's in our Constitution. Here's Article 10, Section 13 of Florida's Constitution. And as you look at the language, ask yourself, from what perspective is this language written? Look at the language. Provision may be made by general law for bringing suit against the state as to all liabilities now existing or hereinafter originating. From what perspective is this written? Do you see language here that says you can't sue the government? Or do you see language here that presupposes the fact that you can't sue the government and instead carves out an exception? I would argue for the latter. I would argue that this language presupposes that sovereign immunity already exists. And indeed, that is the source of sovereign immunity. Sovereign immunity generally is seen as an inherent power of a state. It's not seen as a power that has to be granted to a state, because instead it's seen that the state already has this power. So this language would be an example of our state constitution being a limitation upon power, not a grant of power. Where's the grant of power? The police power, the inherent power, includes sovereign immunity from the perspective of the author of this language from Article 10 of Florida's Constitution. So that again brings us to the unanswered question I posed just a moment ago. Why, in this day and age, would laws making the government above the law persist? And in order to answer that question, let's first look at the concept of font of law and font of justice. Join me in the text, would you? So, here we go. Okay, the doctrine of sovereign immunity comprises two distinct rules, which are not always separately recognized: font of law and font of justice. The one holds that the king or the crown, as the font of law, is not bound by the law's provisions. The other, font of justice, provides that the king or crown, as the font of justice, is not subject to suit in its own courts. The font of law rule puts the sovereign beyond the reach of the law. The font of justice rule puts the sovereign beyond the jurisdiction of the courts. Now, why would you want either or both to be true? We're getting to that answer. To get there, join me in the notes and questions to consider. First, let's take a look at note one. Note one, why in the modern era would a concept such as sovereign immunity still exist? Imagine that sovereign immunity did not exist, and a jury is so offended by the action or inaction of the state of Florida that it awards damages against the state in the amount of $20 billion. Where would the state of Florida obtain that money? My fellow Floridians, look in the mirror. That's where the state of Florida would obtain that money. I have 10-year-old Patrick, 7-year-old Madeline. Look at them as they grow up and become taxpayers. That's where the state of Florida would get that money. Think about their children and their children's children. That's where the state of Florida would get that money. The next question in note one asks, what Florida bills and obligations would be unpaid in order to satisfy that judgment? The schools? The hospitals? What government services would Florida stop providing in order to satisfy that government? No more ambulances? No more law enforcement? Does this scenario illustrate how it might be in the best interest of Floridians for the state of Florida to have sovereign immunity? And I hope so, because that's what I was trying to do when I wrote this note. I'm trying to illustrate that there could, arguably should, still be sovereign immunity in this day and age. Because who pays a judgment against the state? You and I, the citizens of the state, and our children, our children's children. As egregious as the state's actions may be in a given case, should that mean we have to give up basic services for ourselves and for the next generation and for the generation after that in order to simply satisfy one judgment or several judgments or a handful of judgments or a year's worth of judgments? Should my generation's sum total of all judgments against the state bankrupt the state from now and into perpetuity? Is that good for society? Maybe not. Note two. Certainly it is practical for the state of Florida to have sovereign immunity, but in your opinion, is it equitable? Imagine a plaintiff who is injured catastrophically by the negligence of the state of Florida, and for whom all experts agree has suffered economic damages in the form of wage loss and future medical care in the amount of $12 million. Imagine that Florida's sovereign immunity caps that damage award at $300,000. Does sovereign immunity create a fair result for such plaintiff? And again, that's a matter of perspective, isn't it? Put yourself in the shoes of that plaintiff. We're talking about economic damages. We're not talking about pain and suffering. We're not talking about punitives. We're talking about out-of-pocket money, lost wages, and medical bills that you got to reach into your wallet and pay for to the tune of $12 million. Here's 300 grand. Go ahead and pay the 12 million with that. Can't do it. Can't do it. Is sovereign immunity equitable? That's a policy decision. That's for you, future lawyers, to influence. Note 3. In the scenario from the last question, has sovereign immunity achieved its goal of protecting the public treasury in such an instance? Oh, but we've got to protect this generation, next generation, going to bankrupt the state. We already heard that speech, McGinley. Look at the flip side of that speech. After the plaintiff's $300,000 award is exhausted, will the plaintiff turn to public assistance to finance the balance of the plaintiff's future financial needs? Of course. Of course. Hopefully the church is there. Hopefully the family is there. Hopefully the community is there. Hopefully society is there. But certainly in this day and age, the public treasury is there too, is it not? Will this adversely affect the public treasury? Yes. Yes. So I hope that illustrates the pros and the cons of sovereign immunity and helps you think about that. But let's talk about when and where does sovereign immunity apply, because you're a future lawyer, right? You're either going to be advising someone as to the legal rights. You may even be litigating their legal rights. Can you even file suit? And we've got that lamp ruining that slide again. I'm gonna move the lamp. Is this like a milk game? Do you take a drink of milk every time I say move the lamp? Milk. Okay, hold on. All right. There we go. It's not flattering for my skin tone. Anyway, the slide's more important than my skin tone. So there's 3 separate issues that we're going to talk about. I want to break down sovereign immunity into 3 separate groups or things to think about, okay? And the first thing I want you to think about is number 1 over here. Is the state of Florida and or its counties and or its municipalities immune from a state law claim? State law claim? What you talking about, McGinley? What I'm talking about here is a lawsuit, a cause of action that arises not under the federal law, but under state law. For example, breach of contract, for the most part, is a state law claim. A tort, personal injury, is a state law claim. There are state statutes in common law that create a right to recovery, create a cause of action when it arises out of state law. That's what I'm talking about here. Number 2, carve this out separately. Is the state of Florida immune from a federal claim? Notice the list got shorter. Back here in state 1, I was talking about state of Florida, counties, and other municipalities. Over here in number 2, I'm just talking about the state of Florida, okay? Is the state of Florida immune from a federal claim? Different from a state claim. And number 3, let me pick up the folks I left behind, are the counties and municipalities and entities they create immune from the federal claim. Maybe drawing this might make it easier to understand. All right, we got here the whiteboard. Okay, we got the marker. Okay, all right, and we got my lap. Okay, all right, now, so we've got 3 groups we're talking about here, okay? We've got state of Florida. I'm right-handed. Not bad for left-handed, right? And then there's counties, right? T-I-E-S. I should be writing with our right hand. All right, bear with me. Making a switch. Okay, so we got Florida, we got counties, and we got other municipalities. Is it just me who thinks maybe my left hand was the clearer writing? Okay, so you got these three groups, right? And then over here, that's the who. Over here now is the what. We've got the state law claim, right? And we got the federal law claim, all right? Now I want to break it down. I want to look at it in three different ways. The first thing I want to look at is all three groups, all right? Are they immune from that? That's number one up on the big board. See, number one, that's the first thing we're going to look at. You know, if this lawyer thing doesn't work out, I'll just go into video production. So smooth, right? Okay, so that's the first one we're going to look at. Are those three groups immune from the state law claim? And here is the general rule. It is the common law rule. State of Florida and Florida immunity is total, but lesser sovereigns are not. State of Florida is immune, and counties that are exercising the arm of the state are immune. But municipalities are not immune from tort liability when performing the municipality's proprietary functions. Remember the source of sovereign immunity. It wasn't a statute, it was inherent. This is that inherent immunity, okay? This general rule. State of Florida, immune. Lesser sovereigns, not immune. When is there an exception for the lesser sovereigns? First exception is for a county when it's exercising the arm of the state. When's it doing that? When the state has a non-delegable duty, when the state has a job to do, and it involves the county in fulfilling that obligation, then the county takes on not only the obligation, but the sovereign immunity of the state, because the county is the arm of the state. There's one more exception, if you will. Municipalities are not immune from tort liability when performing the municipality's proprietary functions. What are we talking about there? A municipality has the right to own things. Like you and I, a municipality can be a proprietor. For example, the county has vehicles. Maybe it has ambulances. Maybe it has trucks. Maybe it has golf carts. Maybe it has ways of getting county employees around town. And maybe one of those county employees might negligently operate the vehicle and strike someone. That would be a tort. Municipalities are not immune from tort liability when performing the municipality's proprietary functions. So there you have it. There's the general rule. That's what is inherent. But remember what Article 10 in the Constitution said? State of Florida has the right to pass laws that alter this. Has the state of Florida passed such laws? Absolutely. The statutes are replete with them. I'm not going to spend the next 10 hours going over each and every one. Let me go over the one that is the most common in the case law. That is in Florida's tort law, which is Chapter 768. Specifically, 768.28 varies what you see right here when it comes to torts. 768.28 works this way. The state and its agencies and its subdivisions shall be liable for tort claims, but liability shall not include punitive damages or prejudgment interest. Neither the state nor its agencies or subdivisions shall be liable to pay a claim or a judgment by any one person which exceeds the sum of $200,000, or when totaled with all other claims exceeds the sum of $300,000. That portion of the judgment that exceeds these amounts may be paid in part or in whole only by further act of the legislature. Okay, so that's the language. What does it mean? How does it work? Let me give you an example. It's a totally hypothetical example. I'm making it up as I go along, but it's also accurate. Say you are the lawyer and you're representing the plaintiff and you have a great day in court. I mean, you're just brilliant. The jury's hanging on your every word. Your client truly is injured and the jury understands it. They feel it. They sympathize with it. all because of your brilliant lawyering. The jury comes back. The judge asks, have you reached a verdict? Yes, we have, Your Honor. Who do you find for? The jury foreman says, we find for your client. We find for the plaintiff. Did you arrive at an amount of damages? Have you filled out the jury verdict form? Yes, we have. Please publish the jury verdict form. Ms. Foreman, read the form. We find for the plaintiff in the amount of $20 million. It's 5:01 p.m. Judge sends everyone home for the day. Come on back to chambers in the morning, and we will enter the judgment. Man, you have a good night that night, don't you? You just won 40% of $20 million. Do the math on that. It's like $8 million. You're having a fun night that night. Probably having a Miller High Life or two. Probably celebrating that $8 million payday, right? And of course, one thing you do is you get the verdict, the judgment typed up out of your word processor for the judge to sign. You go back in the morning. Here it is, Judge. Yes, here it is. $20 million. Sign here, Judge. Enter the judgment. Judge takes that paper. Yes, I'm going to sign. Oh, one thing I have to change, though. Judge crosses out $20 million and puts what instead? That maximum amount. What? That, my friends, is how sovereign immunity works. It's how this statute works. Now, the verdict form said $20 million, but the judgment, the part you're enforcing through the court system, that's subject to this cap. That's way shy of $20 million. But don't forget this language down here. You can collect the rest, right? That portion of the judgment that exceeds these amounts may be paid in part or in whole only by further act of the legislature. What's that mean? Well, you fill out a form, right? You get your friendly neighborhood legislature to pass a law that awards you the difference. That's right. Courts can't help you. Now you got to turn to a lobbyist. And do you think you're the only one in the legislature that would like an individual law entered in just their own favor? No, you're not alone. There's a committee. They're adding your proposed law to a big old stack of laws. Might never get to it. Most of them never pass. So there you have it. That's sovereign immunity, both under the common law and under Florida Statute 768.28. I hope that hypothetical helped it make sense to you. So what we're talking about there, I thought was well stated by Justice Cantero in a dissent that he put in this particular American Home versus National Railroad case. Sovereign immunity of municipalities must be construed strictly, whereas immunity of state must be construed more broadly. Under the common law, the state's immunity was total, but municipalities never enjoyed total immunity from suit. Before 768.28, in proprietary functions, a municipality had the same tort liability as a private corporation. Essentially, the state and its agencies on the one hand, and municipalities on the other hand, arrive at 768.28 from opposite directions. A status of near total immunity for the state and a status of near non-existent immunity for the municipalities. So 768.28 took the near total immunity of the state and made them liable. At the same time, 768.28 took the near non-existent immunity of municipalities and gave them some immunity. I thought that was an interesting observation, and it's absolutely true. So that brings us to this case, Panam versus Department of Corrections. Let me, if you will, take some poetic license with the facts of Panam versus Department of Corrections, because we're all friends here, right? So, I got the inside track on this case. I know what really happened. Nah, I'm just taking some poetic license. So anyway, Department of Corrections entered into a contract with Panam to provide some food, right? And it was a big bill. So Department of Corrections didn't pay. Panam said, hey, give me my money. Department of Corrections said, hey, that's a big bill. We're not going to pay. So Panam went to court, filed a very simple collection suit, said, I got a contract. I provided the goods and services. All conditions precedent have been met. We're not in breach. Department of Corrections is. They didn't pay us. We want our money. Department of Corrections lawyer stood up and said, yeah, that's all true, but we're not going to pay. Sovereign immunity. Have a nice day. If that had been the facts, it's awful close. That would be absolutely correct, right? Right? Because the state comes under the general law with near total immunity. Where was the waiver? You didn't see it in 768-28. That had to do with torts. You don't see a waiver when it comes to contracts. Then the Supreme Court of Florida takes up the case in 1984. What was the ruling of the Supreme Court of Florida? The Supreme Court of Florida ruled that under the plain language of Florida's Constitution, which we won't bother to quote to you, we're not going to tell you which section or which paragraph or which sentence or quote the sentence. No. But in the Constitution, under the plain text, if the state of Florida willingly enters into a contract and breaches that contract, then the state of Florida has waived its sovereign immunity and is liable for breach of contract, just like anybody else would be. That's the holding of Panam versus Department of Corrections. Or at least my paraphrase of it. Now, let's take us to our notes and questions to consider. Note 1. How can the outcome of Panam versus Department of Corrections be reconciled with these prior rulings from Florida Supreme Court? Here's a 1968 opinion. Quote, any waiver of sovereign immunity must be clear and unequivocal. Remember, they didn't have anything to quote in the opinion. Here's another 1941 opinion. The only way the state can give its consent to be made a party defendant to a suit is by legislative act. Remember, Panam versus Department of Corrections, there was no statute. There's nothing to cite saying that sovereign immunity had been waived. So how do you reconcile Panam versus Department of Corrections with these things? Well, first, let me tell you how not to reconcile it. First, sovereign immunity is not a question of equity. We don't throw sovereign immunity out the window every time it gives us an inequitable result. It's not a question of equity. It is true, and it remains true after Panam versus Department of Corrections, that the only way the state can give its consent to be made a party defendant to a suit is by legislative act. It is true, and it remains true after Panam versus Department of Corrections, that any waiver of sovereign immunity must be clear and unequivocal. The only way to reconcile Panam versus Department of Corrections with those holdings, which remain good law, is to see Panam versus Department of Corrections for what it is: judicial activism. The court carved out an exception to sovereign immunity. It remains an exception, but it is limited to the facts of the case. Facts of the case being breach of contract that the state of Florida voluntarily entered into. We don't throw sovereign immunity out the window. They did in Panam versus Department of Corrections, but we have limited the application of Panam versus Department of Corrections to its facts. Note 2. Panam versus Department of Corrections holds that where the state has entered into a contract fairly authorized by the powers granted by general law, the defense of sovereign immunity will not protect the state from actions arising from the state's breach of contract. What Florida statute says so? Answer, there isn't one. Prior to the decision in Panam, what Florida case law precedent said so? Answer, there wasn't one. What do you call a decision of the Supreme Court of the state of Florida that interprets nothing but the plain language of Florida's Constitution and misinterprets that language? You call it the new correct interpretation of Florida's Constitution. Why do you call it that? Well, they're not infallible because they're final. I'm sorry, they become infallible because they're final. You can't appeal anywhere. How do you get jurisdiction in the Supreme Court of the United States when there's an adequate and independent state law basis, the plain text of the state constitution, and there's no interpretation of federal law involved? Under Michigan versus Long, the United States Supreme Court decision of Michigan versus Long, Supreme Court of the United States lacks jurisdiction. You can't appeal any further from Panam versus Department of Corrections. Did they get it wrong? Yes, they did. What's the end result of that wrong? That's the new correct interpretation of Florida's Constitution. limited to its facts, limited to the instance of where the state has entered into a contract barely authorized by the powers granted by general law. The defense of sovereign immunity will not protect the state from actions arising from the state's breach of contract. Note 3. The holding of Panam versus Department of Corrections explicitly overrules all contrary prior decisions, including one decided back in 1895. When the Department of Corrections breached the contract in the 1980s, did not they have the right to rely on case law precedent dating back more than 85 years? Yeah, they sure did. I'm really carving them a new one with my notes and questions to consider, aren't I? I'm not a big fan of judicial activism. Judges are supposed to call balls and strikes. They're supposed to blindly apply the law. You've seen the justice's blind motto. You've seen Lady Liberty with the blindfold on. That's what a judge is supposed to be. A judge is not supposed to be taking over the role of policy, nullifying constitutions, nullifying the will of the people spoken through their legislature and their elected representatives, replacing the law with what the judge feels the law should have been had the judge been some sort of dictator or something. Not a big fan of judicial activism. For those of you who are, I hope I didn't offend, but I think rule of law is far better than judicial activism. Note 4. After Florida Supreme Court decided Panam, none of the parties sought review from the United States Supreme Court. Under the adequate and independent doctrine as interpreted by Michigan versus Long and discussed in Chapter 1 of this text, would the U.S. Supreme Court have jurisdiction to review Panam? The answer is no. The answer is no. There was an adequate and independent state law basis because the only basis for Panam was the plain text of Florida's Constitution. And under our federalism, who is the final arbiter of the plain text of a state constitution? The state's highest court. So there was nowhere to go. All right, so that brings us back then to where we were before. Oh, here's what Panam is limited to its facts. Said it before, where the state has entered into a contract fairly authorized by the powers granted by general law. The defense of sovereign immunity will not protect the state from an action arising from the state's breach of contract. So that's another waiver of sovereign immunity created through judicial activism. So we talked about number 1. Let's now turn to number 2. And number 2 asks, is the state of Florida immune from the federal claim? And back to our well-written and brilliantly drawn blackboard, what we're now talking about, these 3 parties, that's the who, versus federal claim, that's the what. We just finished talking about these 3 parties versus the state claim, changing our focus now to these 3 parties versus a federal claim. Gosh, glad we've got that. That really cleared things up, didn't it? Okay, so is the state of Florida immune from a federal claim? The federal Constitution, the United States Constitution, the 11th Amendment says the judicial power of the United States shall not be construed to extend to any suit against one of the United States. Florida is certainly one of the United States. Shall not be construed to extend to any suit against any one of the United States by citizens of another state or by citizens or subjects of any foreign state. So sovereign immunity persists and exists despite a state entering the union and being part of our federal system and being subject to the federal Constitution. Because Florida has sovereign immunity, the U.S. Congress cannot use its powers under Article 1 of the federal Constitution to subject Florida or any other state to suit in federal court without the state's consent. There's the kicker, folks. Without the state's consent. That's the key, without the state's consent. Case law tells us that consent can sometimes be implied. Exceptions arise when the text of the U.S. Constitution allows the U.S. Congress to abrogate state sovereign immunity, and then Congress passes a law that properly utilizes that power. So the implication is this. You joined the union, you signed on to the U.S. Constitution. The U.S. Constitution allowed the Congress to pass certain laws. If they pass a law pursuant to that Constitution and they properly use the power under the Constitution, you've impliedly waived sovereign immunity as to that law. Get it? See how it works? Here's some examples. Bankruptcy, civil rights. You're in state court. You're winning. And the defendant rushes in and says, look, here's the copy that shows I just filed bankruptcy in federal court. What happens to state court proceedings? Automatic stay. Stay meaning pause, meaning end, meaning hold, meaning stops in its tracks because the bankruptcy law says so. Civil rights. You would not have it any other way. Can a municipality say, hey, I'm going to discriminate against Americans based on race, sex, color, religion, national ancestry, or other protected status, and I can get away with it because I have sovereign immunity? No, you don't want that. And you don't have that because of this, because of the implied waiver. Civil rights apply throughout our nation. Thank God for that. So that covers number 2. That brings us to our third one. Okay. And I know I'd be remiss if I didn't get the dry erase. So now what we're talking about is not all 3, but just the bottom 2, the counties and the municipalities. Are they immune from the federal claim? Number 2 talked about, was the state immune? See how that's how number 2 said? Was the state immune? Now, instead of is the state immune, I'm asking about the counties and municipalities. Are they immune from the federal claims? And this brings us, Judge Cantero's dissent I quoted to you earlier. Here's the majority decision. Town of Lake Clark Shores versus Page, Supreme Court of Florida, 1990. Municipal defenses, including an assertion of sovereign immunity to a federal right of action, are, of course, controlled by federal law. So the federal law itself is going to tell us not whether the state, but whether the state's lower sovereigns, its counties, its cities, its towns, its hamlets, its other municipal corporations. The federal law is going to tell us whether they have sovereign immunity. The federal law controls that question. Note here that by including municipalities within the class of persons subject to liability for violation of the federal Constitution and its laws, Congress abolished whatever vestige of the state's sovereign immunity the municipality possessed. And it was this simple. When Congress passed these laws, it included the phrase person, and it included a definition for the phrase person. And it said that municipalities, cities, towns, hamlets, villages, counties, said they are within the definition of person. And that's all it took. That was enough to do away with whatever sovereign immunity municipalities had to the federal claims. A state's municipal corporations and similar government entities are persons under 42 U.S.C. Section 1983. Therefore, Florida cities and municipalities lack sovereign immunity from federal law claims. They don't have any. There is the arm of the state test exception. A county can take on the state's sovereign immunity when the county can prove it is acting as an arm of the state. The arm of the state test, it has 3 prongs. But the third prong is really the controlling prong. What the case law says is that there are 3 factors, the third of which is of considerable importance. And then as you look at the case law, anytime the third one's satisfied, then the exception is satisfied. Anytime the third one fails, then the exception fails. But technically there are 3 prongs. First, how the state law defines the entity. Second, what degree of control the state of Florida maintains over the entity. And third, this is the critical prong, or the one of considerable importance, from where the entity derives its funds and who is responsible for satisfying judgments against the entity. So the real crux of the arm of the state test goes back to where our discussion of sovereign immunity began. It started with the money. Remember the policy decisions, the considerations behind common law sovereign immunity. They all had to do with the public treasury. And indeed, the arm of the state test, the third or of considerable importance prong goes back to that concern, goes back to the public treasury. So that's ending where it all began. Now, with that done, it brings us to the next chapter in our book, which is related to the two that we covered today, and which you might notice is only 5.5 pages long. Can I cover a 5.5 page long chapter before this class ends? Let's find out. This chapter has to do with the delegation of government powers. So what we've got here is, I don't know, the other side of the coin, the opposite of separation of powers. What we've got here is a delegation of government powers. So let's take a look at delegation. Florida's executive, legislative, and judicial branches of government may delegate their power, but they can't abdicate their power. That's where a delegation becomes unconstitutional. We can delegate, but we can't abdicate the powers of the executive or the legislative or the judicial. Any delegation of authority requires an intelligible principle to be laid down for the guidance of an administrative official in the performance of the delegated duties. So what's required if a branch of Florida's government is to delegate power that it holds under Florida's Constitution without that delegation being unconstitutional? What's required is this. You've got to have a principle, an intelligible principle that is laid down for the guidance of the administrative official in the performance of that delegated duty. So it can't be arbitrary and capricious. Can't even be arbitrary. Can't even be capricious. Can't be either one. Certainly can't be both. So I gave you there the case of Wiley versus Scott. And here a citizen was successful in challenging Florida's government's, the Florida governor. What the facts of this case roughly hold is this. We had at the time a new governor. He's currently U.S. Senator. This is Governor Scott, Rick Scott. Wasn't Senator Scott at the time. It was Governor Scott. He's new to office. He's promising to put America back to work. He's promising to put Florida back to work. Florida governor. And he's promising to put folks back to work by lessening the burdens of government. One of the things he does is he sets up an agency to oversee other agencies. When other agencies enact a rule, Florida Administrative Code, administrative rules, when they enact some rulemaking, this new agency created by Governor Scott is to determine the financial costs of that rule. Perhaps Governor Scott's goals were accountability. Perhaps they were to keep those campaign promises, to rein in government, especially those regulations where costs outweigh benefits, arguably. In order to determine whether costs outweigh benefits, you got to determine costs. Was the logic? So this new agency was created. This case, Wiley versus Scott, was a citizen's challenge to the creation of that agency. And here's the conclusion. We distinguish between the governor's constitutional authority with respect to the provisions of the executive orders pertaining to review and oversight of rulemaking within the executive agencies under his control and the legislature's lawmaking authority under Article 3 of the Florida Constitution. The legislature retains the sole right to delegate rulemaking authority to agencies. And all provisions in both Executive Order 1101 or 1172 that operate to suspend rulemaking contrary to the Florida Administrative Procedure Act constitute an encroachment upon the legislative function. We grant the citizen's petition, but withhold issuance of the writ of quo warranto. We trust that any provision in Executive Order 1172 suspending agency compliance with the Administrative Procedures Act, in other words, suspending rulemaking, will not be enforced against an agency at this time and until such time as the Florida legislature may amend the Administrative Procedure Act or otherwise delegate such rulemaking authority to the executive office of the governor. It is so ordered. So as you can see from the ruling of the case, what was the problem here? The governor was attempting to have the new agency not only review the rulemaking of other executive agencies, but also to review the rulemaking of legislative agencies. In so doing, this constituted an encroachment upon a legislative function. So this case stands for a second instance of the non-delegation doctrine and when there can be an unconstitutional attempt at delegation. The first instance before this case, we talked about that there has to be an intelligible principle to be laid down for the guidance of an administrative official. That was the first time there can be unconstitutionality, when there's a failure to provide an intelligible principle for the guidance of the administrative official in the performance of their duties. Now, Wiley versus Scott gives us a second instance where there can be a violation of the Constitution of the state of Florida, unconstitutional under Florida's Constitution, when there is encroachment. Here we had an encroachment upon a legislative function because the governor's new agency not only applied to executive branch agencies, but also oversaw legislative branch agencies. We can't have the executive overseeing the legislative when it comes to the separation of powers that the plain text of Florida's Constitution requires there to exist. So that's what that case was talking about. Also under delegation of judicial powers, just 2 pages left in this chapter, so trust me, we will end class on time. Here we've got Pierce versus State. Here, Florida's 2nd District Court of Appeal agreed that a Florida statute resulted in an improper delegation of judicial power. So here the judicial power was improperly delegated. What happened here? Kelvin Pierce challenged a restitution order imposed upon him after he pleaded guilty to theft. You know, he stole money and now he's got to give it back. Of course he's challenging that, right? He argues, and the state concedes, that the trial court erred when it authorized Mr. Pierce's probation officer to establish a payment schedule for the restitution amount. We agree and reverse the restitution order, in part with the directions. And here's what happened. There's an April 2006 sentencing and restitution hearing. The trial court withholds adjudication, imposes a sentence of 12 months of probation, and orders Mr. Pierce to pay $10,515 in restitution to the victim. Notably, the trial court delegated the matter of establishing a payment schedule to the probation officer. That's when Mr. Pierce files a timely notice of appeal. As the state concedes, the trial court erred in its original restitution order when it delegated to Mr. Pierce's probation officer the authority for determining the restitution payment schedule. Florida courts, says the opinion, have long held that the determination of a restitution payment schedule is a judicial responsibility that cannot be delegated. In addition, when the trial court clearly intended to correct its error, we note that the 6 days had elapsed, so there was a procedural problem also. For these reasons, we affirm the restitution order to the extent that it established restitution amount, so he does owe $10,515. But we reverse the restitution order to the extent that it delegated to the probation officer the determination of the payment schedule. So what have you got here? You've got a third thing to watch out for when it comes to an unconstitutional delegation. The executive can delegate to other executive officers. The legislature can delegate to other legislative agencies. The judiciary can delegate within the judiciary, but we can't cross boundaries. We can't have the judiciary delegating to the executive. We can't have the legislature improperly delegating to the judiciary. When it comes to delegation of legislative powers, it's to be delegated to the legislature. Judicial powers are to be delegated to the judiciary. So, hey, how about that? We managed to cover one more chapter. So we remain more than one full class ahead of the syllabus. I hope that's not frustrating to you. I'm not trying to go too quickly through our class, but I am trying to carve out time so that before you take your final exam, I'll have adequate time to review not just a few lectures, but the entire semester of lectures in order to help you best prepare for the final exam. In a world full of what just a few weeks or months ago were unforeseen obstacles, it's not my goal to be one of them. I don't want to make it any harder for you to live your life than current circumstances are already making it. So let me know, let me hear from you how I can help you study. Let me know, let me hear from you how I can help get rid of the obstacles that are within my little purview of being your adjunct law professor. Let me know what it is I can do to help you understand and use this material to pass this class and to become an effective advocate and advisor to your future clients to come join this great profession of ours. And as Deacon Tommy mentioned at the onset, the beginning of our class, Deacon Tommy, if you're listening, thank you again, man. So much appreciate you doing that for us. He can do even more for you. He can be a spiritual advisor. He can be a friend of you like he's a friend of me. If you need to reach him, no shame in that. I'll keep it confidential if you'd like. Reach me at patrick@mcginleylaw.com. I'll put you in touch with him. Or perhaps you have a different faith. If your faith brings you comfort, if it brings you strength, if it brings you joy, then God must be behind it. Because the Lord your God, he loves you. Coronavirus or not, he loves you. And he is here for you. And until we meet again, my wife Bernadette and I are going to continue to keep you in our prayers. If you're the type to pray, please pray for us. May God bless us all and continue to bless us all. See you in 1 week. Thanks for joining me. Take care.